हेलो फ्रेंड्स, स्वागत है आप सभी का यहाँ पे एक बार फिर से। बैंक स्ट्रीम की एक नई अपडेट के साथ यहाँ पे आप लोगों के लिए ऑल इंडिया स्टेट बैंक ऑफिसर फेडरेशन की अपडेट है। दैट इज रिगार्डिंग द पेंशन रिलेटेड इश्यूज सजेशंस 4th July 2023 circular number 45. So we have sent a communication to Deputy Managing Director HR and Corporate Development Officer स्टेट बैंक ऑफ इंडिया ऑन द कैप्शन सब्जेक्ट। तो उसकी जो कॉपी है वो यहाँ पे फ्रेंड्स एनक्लोज्ड है, उसको यहाँ पे आप लोगों के साथ यहाँ पे शेयर करेंगे। यहाँ पे काइंडली मेक श्योर टू सब्सक्राइब टू चैनल को दोस्तों जो सब्सक्राइब कर लेना फॉर द लेटेस्ट बैंकिंग एंड पेंशन रिलेटेड अपडेट्स के लिए। दिस इज अ कॉपी ऑफ ऑल इंडिया स्टेट बैंक ऑफिसर्स फेडरेशन 3rd July 2023 का सर्कुलर है ये। द डेप्टी मैनेजिंग डायरेक्टर HR कॉर्पोरेट डेवलपमेंट ऑफिसर SBI मुंबई पेंशन रिलेटेड इश्यूज सजेशंस। So we most humbly invite your kind attention to a few crucial points regarding the pension related concerns of State Bank of India retirees for making improvement in pension scheme. The concerns have been communicated earlier also and discussed in detail many times including CNC meeting. We understand that HR team under your able guidance is already working diligently to present these matters before the committee constituted by the Government of India Ministry of Finance. However, we would like to emphasize the following points for your kind. First is non-inclusion of SBI pension issues in wage negotiation. It is important to note that SBI pension issues are not discussed during wage negotiations. Any amendment in the SBI pension fund regulation has to be made after consultation with the Reserve Bank of India and with the previous sanction of the central government by the Central Board of SBI. The ceiling on pension has been revised in SBI in the past by duly following the same procedure. Second is historical background of pension ceilings. The monetary ceiling on pension has been prevalent in the SBI pension scheme since the presidency days. The initial ceiling on pension for senior officers was fixed as Rs 750 and Rs 1000, adopting the ceiling fixed by Bank of Bombay, which was linked to maximum salary of senior grade officer in the bank. The revision of pension ceiling for the 4th and 5th BPS retirees was based on 50% of the maximum salary of the senior grade officer at the material time. The logic behind the fixation of 50% ceiling on pension was to ensure uniformity and avoid subclassification among employees. However, this pattern was changed for retirees from 6th BPS onward, leading to an anomaly that could have been rectified by the Murmuru Committee. Next is regarding illogically and discriminatory fixation pattern. Illogically and discriminatory pension fixation pattern. The decision to link the fixation of ceiling on pension to maximum salary of junior management officer in the year 2006 is arbitrary and illogical. This has created two separate classes of pensioners within the same organization, which goes against the principle of natural justice. Approximately 85% of the pensioners, including subordinate staff, clerical staff, and junior officers, are already drawing a 50% pension. However, the remaining 15% of the officers are deprived of this benefit, resulting in an unjust disparity. The Murmuru Committee justified the concept of 40% pension instead of 50% after certain pay ceiling by citing the three retirement benefits in SBI, including the employer's 10% contribution in the Provident Fund. However, this provision results in discriminatory treatment as it provides non contributory pension to some categories of employees and contributory pension to others. The fixation of pension ceilings through arbitrary changes in the pattern is not permissible by law and is violative of Article 14. So it leads to subclassification of pensioners and discriminate against the rules regulating all pensioners. So the pension ceiling should be set at 50% of the maximum salary of senior grade officer. It is worth mentioning that pensioners of all public sector bank, RBI, NABARD and state government and center government are already drawing a 50% of the pension. Neutralization of dearness allowance on pension for those who retired before 1st May 2005. So the issue of neutralization DA on pension for those who retired before 1st May 2005 remains unresolved despite the introduction of 100% neutralization of DA relief from 1st May 2005 onwards. So this has resulted a significant number of retirees who retired prior to the effective date being paid dearness relief based on the earlier tempered slab system. As a consequence, these retirees are deprived of the necessary relief to cope with the escalating cost of inflation on essential commodities. Next is regarding introduction of special allowances. So in the 10th BPS, a special allowance called the special allowance was introduced to address the superannuation burden for the management. So this decision was imposed by IBA due to their inability to provide sufficient cushion toward the basic pay, considering the substantial provision required for the pension fund and the industry's financial constraints. So consequently, the IBA agreed to allocate only 2% toward the load on basic pay, while the remaining amount was granted as an allowance. So it was explicitly stated in the agreement that this allowance would direct DNS allowance and would not be considered for the purpose of payment of superannuation benefits. So the special allowance was designed as a universal allowance provided to all officers working in the bank, and it was not specific to any duty or functional role but rather extended universally across the organization. However, a landmark judgment by the Supreme Court, while considering a batch of cases filed at various courts, clarified the treatment of allowances for the purpose of superannuation benefits. The Supreme Court ruling established that any special allowance linked to basic pay or forming a part of basic pay paid to all employees without any specific responsibility or duly attached and paid perpetuity along with the basic pay should be considered as part of the pay. As a result, employees are entitled to receive superannuation benefit calculated inclusive of such special allowances. So therefore, the decision of Supreme Court holds the force of law and is applicable nationwide. Any agreement or provision that contradicts this interpretation is considered null and void, requiring appropriate action on the part of the management to regularize the situation. And it is essential for the management to acknowledge and comply with the Supreme Court's ruling, as it sets a binding precedent and establishes the legal framework for determining superannuation benefits by taking appropriate actions to rectify any inconsistencies with the court decision. The management can ensure fair and just treatment of for all employees in accordance with the law of the land. Next important is regarding commutation of pension and is updation of pension after every wage revision.